Hello and welcome back to Felony Miami. I'm your host, Joe Stone, and in the studio today we have three guests, three heavy-hitting criminal trial lawyers. To my left, Sabrina Puglisi. Sabrina is a Florida board-certified criminal trial attorney since 2008. And in Florida, there are only 370 board-certified criminal attorneys out of approximately 85,000 attorneys. That's just here in Florida. Or is that just in Miami? It seems like it's just in Miami.
I don't even know the answer to that. We're already starting with tough questions.
Yeah, right to it. She has the unique experience of having worked for both the Miami-Dade Public Defender's Office and the Federal Defender's Office for the Southern District of Florida, where she has gained invaluable experience as a trial attorney, handling hundreds of different cases from pre-trial to trial. Thank you for being here. Welcome.
Thank you for having me.
Absolutely. And directly in front of me is Peter Schoenthal. Showing it all, Schoenthal.
The best way to remember it.
Peter is a skilled criminal defense attorney who has dedicated his life to his passion, trials. Peter believes that a criminal defense attorney must not only embrace but thrive while in trial in order to fully serve one's client. Trial is deemed as a dying art as numbers have dropped over the years due to plea bargains, I'm sure.
And mid-mans.
Yeah. And min-mans, yeah. However, this is an art form that he has dedicated his life to, and in order to best serve those who he represents, Peter describes himself as an old-school attorney with a new-aged approach. Welcome to the show.
Thank you for having me.
Thank you for being here. Okay, Alfredo Izaguirre.
There you go.
I got the R roll in there. Alfredo is a Coral Gables criminal defense lawyer serving clients in criminal or civil matters statewide. Alfredo has tried some of the most complex cases in several districts of the county, and including those stemming from international allegations, and he has claimed victories in all of those arenas of law, and recently obtained an acquittal in federal court for a client who was charged with murder and kidnapping and was facing the death penalty. Congratulations.
Awesome.
Thank you.
Thank you for being here.
Thanks for inviting me.
All right, so let's get right into this. Do you guys feel like you have to shower and bathe after your day's work as criminal defense attorneys, or is that like...
Well, I think it's always good to shower and bathe after a long day's work, but no, not not necessarily. A lot of people will be like, "Oh, how do you do what you do?" And I don't. A lot of it's representing the Constitution, and I think all of us have the same feeling that we have a passion for what we do, so we love what we do. So, at the end of the day, it's a lot of work, and it's long days, but I don't feel like icky or anything like that.
There's never been one day I've ever been ashamed of what I do. I think that we're fighting the good fight. We are on the side of people who, so many people ditch them during these hard times. Most of them just have made a mistake, and we're there to stand by them and help them.
I would say that all we do is make sure that the prosecution, whether it be the U.S. government or the state government, prove their case.
Right.
And if they can't prove it, then that's it. That's our job. Make them prove it. Make them prove beyond a reasonable doubt that somebody did what they're charged with.
Right. Because, one of the things that that I think people have... I think television and media has created this thing that people all of a sudden are guilty just because they've been charged. And it's a fact that in our criminal justice system, you are supposed to be innocent until proven guilty.
I think the misconception about criminal defense attorneys is that we can be like magicians or we're looking for these loopholes. When really I think a lot of our job is to make sure that all the actors in place within the government, the police, the FBI, state attorneys, federal AUSAs, our job is to make sure that they're doing their jobs and they're doing it correctly and not cutting any corners and messing with people's lives. It's our job to make sure that the system is working and making sure that no one is wronging people when they shouldn't be wronged.
But I think one of the sad facts, the truth is that, people believe you're guilty until proven innocent.
Yeah,
and
for sure.
That's
Yeah.
why there's so much fewer trials now, because jurors, they come in and, it's easy for a judge to say, do you believe, will you agree to follow the law? And for them to parrot, Yes, yes, I believe that. When in reality, we all know they don't believe that.
Yeah, do you ever think, I just was having a conversation with somebody the other day, do you ever think like looks have anything to do with this? Like if somebody's not, and I'm not saying black or white, I mean somebody that's maybe more attractive than somebody else?
That has a lot to do with it.
That does,
You know,
right?
Sometimes, a female juror could say, oh, that individual looks like my son. He reminds me of my son.
Right.
Or, oh, that person looked like somebody who used to, I don't know, do something bad, or that guy looks like a bad guy.
Right. Or
he's
a male
got a-
juror could be like, I'll
Right.
get with her. She's kind of.
Right. Or
It's human emotions to when you first see someone to make judgment. I mean, we all do it. To say that we don't would be a lie, and I think that happens in a courtroom. I think when people, look at your client, they're making preconceived, notions and judgments, and we do that with jurors. When we do our voir dire, I'm getting a little glimpse into their lives, and I'm making judgments right there when then the panel walks in.
And a voir dire is when you question.
pick a jury.
You pick a jury,
Yeah.
yeah.
Okay.
Ask 'em
That's,
questions.
And so when people walk in, I'm automatically, the first thing I'm doing is making judgments. And sometimes those judgments change, but I think that's just human nature.
judging a book by its cover.
Yeah.
Yeah. That's obviously how we got that expression.
That's why so often, when I used to be a public defender, and depends on the clients you have, but you're always trying to make sure your client looks nice in a trial, right? I mean, you don't send them
Suit and tie,
you say
haircut,
wear
yeah.
your best church clothes.
Sure.
You're trying to give the impression.
Exactly.
It's kind of tricky, though. If it's a drug case, you don't want a $10,000 Armani suit. No. Keep the expensive watch at home.
Watch and rings
Right.
at home, yeah.
Right.
So you mentioned the police and keeping everybody in line and the prosecutor. Have you guys experienced corrupt police, corrupt prosecutors that come in and just absolutely lie? And have you been able to catch them?
Yes.
Tell me a story about that.
Yes. I think in any field, you have good and bad. You have good apples, bad apples. So in the legal field, there's plenty of bad lawyers, but there's plenty of good ones. And I think same thing with police and same thing with prosecutors. I think the most dangerous prosecutors sometimes are the ones that their sole goal is to win. It's not about justice. It's about I want to win.
Well, you guys both worked, Sabrina and Peter, you both worked in the defender's office, right?
Yes.
Yeah, you did.
I did not know.
Okay. So, I mean, that must have given you a slightly different perspective on the whole relationship, right? I mean, has it?
Yes and no, but I think because you deal with prosecutors all the time.
Yeah, I mean,
too.
there's certain prosecutors have certain reputations. Oh, this person is unreasonable. You have to either threaten them to go to trial or actually go to trial, and then potentially get a good deal when the jury's outside.
Right. And
That kind of deal.
So let's
yeah.
say before you go to trial, because I know, Peter, you love going to trial. I'm assuming all three of
Yes.
you love going to trial. That's like,
Can't do this
that's
if you
where
don't
you-
love it.
Yeah.
right,
Yeah.
that's reason. But how often are you caught up in between the actual going to trial and taking the plea, and do you leave that decision solely up to your client?
Well, I do mostly federal now, more so than state practice. And in federal court, it's very rare that cases are going to trial. And there are various reasons for that. But we have an obligation to always confer a plea to our clients. We have to. So at the end of the day, I always leave it in that person's hands. I say to them, it's not my life, it's your life. These are your choices, these are your options, these are the pros and cons, and you have to make that decision yourself.
Yeah.
But, as far as the prosecutors go, I think it depends on how personally they take it. If this is, because this is really a job, and we're all just doing our job, and
Just
we
people.
can agree to disagree. I'm on one side, you're on the other side. And I hope that I can go to work and at the end of the day go home knowing this is a job for me. I'm passionate about it, but it's still a job. And the problem you run into is when you see those police officers or those prosecutors that take it personally. It's not just a job for them. They either have some vendetta against that particular client or that issue.
Right.
That's where you run into problems.
Yeah.
And I think that's why mitigation is also so important, because the purpose, at least for me, with mitigation is
Now,
how
when
do
you say mitigation, what do you mean?
I was going to basically, how do I take my client from being a number or a defendant and make that a human being to the prosecutor and showing that this is a real person who's, there's pitfalls in their lives, things have happened to them, things in the system have happened to them, and it kind of gives the prosecutor a better grasp of who that
Try to
person
humanize
is. And humanize them,
Yeah.
yes, humanize.
Yeah. Interesting. So you do use that as a technique to try to get through to the prosecutor to create, hey, this is a guy, he had a mom, he had a dad, he had a grandma, he had a grandpa.
In plea negotiations always, because, a lot of times in plea negotiations, you're kind of coming with your hat in your hand and you're trying to, accomplish a certain goal. But I think while doing that, and I think we'd all agree, it's important that when you get a case, you always think from the back to the front. You're preparing it for a trial and you're preparing it the best you can while also doing those little things, because you have to be ready for everything. And the better you prepare for trial, the better you find defenses, the better you find ways through the law to better your case. That also strengthens your negotiation along with your mitigation,
Right.
and that's why it's important.
So, Alfredo, when you got this guy off for murder and kidnapping,
Yeah.
He was facing the death penalty. Just real quick around the table, who here is in favor of capital punishment? Sabrina? No? Blank faces.
But I'll tell you, my reason is just because I think the death penalty, if you kill somebody, it's a much quicker.
Easy way out.
It's an easy way out. I think that if you are deserving, you have committed that ultimate crime that is so heinous, you deserve to sit every day in prison for the rest of your life, no TV. Like, it should be a horrible life. It shouldn't be as quick as, now you're dead and done.
Not only that, we just get it wrong too many times for it to be. It's I understand why certain people would like it in theory, but there's just been too many instances where we've gotten it wrong, and it's too late to overturn that wrong.
Yeah,
That's very
exactly.
true.
So, and you obviously don't believe in capital punishment.
I think that it's excessive. In some cases, it is appropriate, but obviously not in all. So, kind of gray area, I guess.
So, how did you approach getting this person that was convicted of murder and kidnapping acquitted?
Well, the initial issue of potentially why the death penalty was waived is the individual that he was accused of killing was also a drug dealer they had abducted. So this, I guess, victim had ripped off a lot of drugs.
So the victim was a bad guy.
Yes, exactly.
So that made it like,
yeah. So the issue of
Kinda-
the issue of death or life never went to the jury. It was waived before the actual trial started.
And that's because you brought that
We
to them?
brought that, that this was not a law-abiding, altar boy, squeaky clean individual.
Reverse
he was-
mitigation.
Right. He was somebody who ripped off drug dealers.
Oh, okay. Okay.
And then the jury obviously then found him not guilty of the murders.
And how long did that trial take you to?
That trial took about I want to say a week and a half, 6-7
the
days.
actual trial, but how
Yes.
long did the whole thing
The
take?
case
you?
was about I want to say 10 months,
10 months.
a year. Yeah.
What's your guys' average time to prepare for a trial?
They're all different. You guys are more.
I mean, for like a heavy crime, murder or something.
It depends if it's
Yeah.
state court or federal
Yeah.
court. So in state court, trials take a long time to prepare. You could be 2, 3, 4, 5 years even before on a death penalty case. It could be at least 5 years before you're going to get to court. But in federal court, things move much, much faster. So it's unheard of to do a death penalty case, within 10 months. I mean, that's unheard of.
My case was continued twice.
Yeah.
I have state cases of murders that I've been working on for about 3 years, and the federal case was continued twice. My state cases have been continued about, we're going on continuance number 25.
Wow.
So,
And why do these things get continued? Explain what that is when you're in a trial.
In state court, you have the right to take depositions.
Okay.
So you have, in a murder, there's, a lot of police officers, a lot of witness, victims, CSI. So you have to take depositions, especially in a murder case that it's going to go to trial, and the stakes are high. And if you don't depose one of these individuals and the defendant ends up getting convicted, and there's issues about whether you did or did not do a good job because you did not take every deposition on the case, So you do have to take every single deposition and interview every witness.
Right.
So that does take a lot of time.
And that's not always easy. You got to serve subpoenas. You got to find out where people are. Oftentimes, people will reschedule. They won't come in for depositions, and those depositions are extremely important to unraveling not unraveling, but learning about your case. Depositions are oftentimes the best place to learn about your case, which is why federal is a whole different animal.
But honestly, that's what makes his win even more
Yes.
impressive, is because he
Right.
wasn't
Thanks.
entitled to depositions, reports, all
But you're
those
not
things.
entitled to that at the federal level?
In federal, you know what the police officer is going to say when he gets up there. Sometimes you have a brief report, but you don't ever have the right to confront the witness before they testify.
They call it trial by ambush.
Yeah,
That's the federal level.
right. The conviction rate's, I think, like 95%.
It's 90, yeah.
It's insane.
Do you guys ever ask your clients if they did it?
I don't really care if they did it or not. I don't really ask that because it doesn't matter to me whether they did it or not. That's not what my job is. My job is to fight for that person the best way that I can.
I don't ask that
I
either.
don't, I
You
don't,
don't ask it.
No.
I don't ask it specifically, but I do try to encourage my clients to tell me as much as possible, and that when they speak to me, it's a safe space.
Right.
We have confidentiality, because the more I can learn from my client, the better it helps me prepare for the case. I know it's
How does
coming.
that? But how do you square that if oh lovely, sorry, we have some work being done in the building today. No worries, our trusty engineer will get that out, I'm sure, in post. But so how do you square that though if you're looking down the barrel of somebody that you know is being honest with you and said, yeah, you know what, I did that. That's right. I mean. How do you move forward with that, with defending them if they get super honest with you and let you know that they did it?
You represent the Constitution. You know, when we take our oath, it's to represent our clients to our best ability, to give them the best defense possible. And remember, our job is still to make sure that the state or the federal government and all other actors are doing their jobs and that they're not doing anything wrong. I think the documentary "Making a Murderer" is kind of one of the best examples of that. You know, who knows what really happened, but those type of acts, no matter whether you're innocent or guilty, cannot be done to ensure proper justice is being carried out.
And you can still go to trial with somebody who tells you that they've done it. Now, there's questions about whether you can put that person on the stand or not
That's
to
an issue
testify.
with,
Because if you honestly believe that that person is going to lie, you cannot put them on, or they have to testify in a narrative.
Would you suffer some consequence if you knew?
Potentially.
Really? What kind of consequence
you'd
would
be
you suffer?
helping them commit perjury and potentially the Florida bar.
It's unethical.
Yeah.
Okay.
So sometimes if you ask, hypothetically, if you ask, they say yes. Okay, now they have admitted to you that they said yes, that they did it.
Yeah.
In the middle of the trial, now he said he never wanted to testify now in trial. He says, I want to testify and say that I didn't do it. Right?
Dilemma.
Now you're in a pickle.
Yeah.
Well, if I have this guy testify, he told me he didn't do it. He told me he did it. Now he's going to go up there and say he didn't do it. Now I'm going to help him commit perjury. So now you have an ethical issue with the
So
Florida
what
bar.
do you do if that happens?
I personally never ask them if they did it or not.
But what if that happens? What
If-
do you do? Do you say, hey, wait, hold time? What's the procedure? What do you do?
Technically, I think you just ask him, well, what do you want to say about what happened?
Yeah.
And you just let him go and say, him or her, say whatever it was that they want to say and get off their chest.
I mean-
without you.
But no, let's
I've
say
had like
that's
100
specific.
trials,
Yeah.
and I've never had that situation
never had that happen.
No, so I mean, I think that's like maybe the law school exam
Yeah.
question for ethics.
Oh, yeah.
What you're
Okay.
asking, it's just not what would happen in everyday life.
It's just, okay, so this is...
The tough questions are starting.
It's a scenario.
Yeah,
The tough
right.
questions are coming.
What would you say the most difficult part of the criminal defense trial? What part of preparing or actually presenting? What's the most difficult part for you guys?
I think voir dire, because I think you can win or lose a case
Yeah.
with your jury. And it's very, very difficult. You are trying to pick 6 or 12 people, depending on if you're in state or federal court. You're trying to pick these people who you don't know.
Right.
You've never met them before. You've got a piece of paper that they've written some thoughts about, answered some questions.
Okay.
And in federal court, some of these judges don't even allow you to ask any questions of these people. So how are you supposed to know whether someone is going to be fair and judge your client, appropriately?
So what kind of questions do you ask a potential juror?
What do you
I mean,
think of somebody who's behind a police car?
Mm-hmm.
I think they
Oh.
did something.
I mean, I ask you have anything like that, or I ask them where they get their news from. You know, I'll pose it.
Okay.
You know, do you watch local news? Do you CNN? I try not to.
You're
show
looking to
them
get
what-
rid of those Fox viewers.
Yes,
I know
exactly.
that.
but I'm trying
Come on,
to,
man.
but I'm trying to phrase it in a way where they don't kind of know where I'm going. You know, I always make the joke that my mother's addicted to Facebook, so she gets her news from Facebook.
Okay.
You know, I watch local news. You know, I have friends that watch CNN. Where do you get your news from? Because when we go,
No, you want those people that are saying NPR.
yeah, well, we're the last.
Hell yeah.
In voir dire, we're the last ones to go. So they've heard a lot of these questions. They're kind of either zoning you out or overly tuned in.
But the defense is the last one to ask?
Yes.
Okay. So the prosecution asks, does the judge
The
ask?
judge first
Judge
asks.
Judge
asks
first.
Okay.
Yes.
And what kind of questions is he asking usually?
Usually they have
Standard,
standard questions
They do.
that they have, like, they'll have the people answer them in a little sheet of paper
Okay.
beforehand.
Like, have you ever been arrested?
Yes.
Okay.
Yes. Have you been on a trial before? Was
Okay.
it a criminal or a civil trial?
Okay.
Don't tell us the verdict. Just did you guys reach a verdict? Were you the foreperson?
Has anyone you know been a victim of a crime? Have you been a victim of a crime?
Right. Okay. And then the prosecution goes,
And then the defense after.
and then you guys
But
are last.
a lot of times the questions that the judge asks are questions
Yes.
where they want the response of, yes, I can be fair and impartial. Instead of saying, hey, what do you think about this case? They'll ask you, hey, sir, you can be fair and impartial in this trial, correct? The person's going
Right.
to say yes.
They'll actually specifically, do you think you could be fair and impartial in this?
As they sit
they'll-
up
they'll-
here looking
Yeah.
down, can you
Yeah,
be
yeah,
fair
sir.
and impartial?
Yeah.
They'll
Do you
kinda lead you.
understand a person
Yeah.
has a constitutional right to not testify, and you cannot hold it against them if he chooses not to testify? Do you understand that? And will you agree with that? What are they going to say? No, but everybody wants to hear from the defendant. Have you ever met anybody who doesn't want to hear from somebody?
Yeah. I mean, I've sat on a jury. I was actually
Criminal
the
or
foreman in a federal criminal case.
Oh,
Okay.
Oh,
look
wow.
at you!
Yeah, no, it was super cool. And I was the foreman. I was very...
You're,
like, I got this.
You can do this with us.
Yeah.
We'll start asking you
It was
questions.
honestly, and I would encourage anybody that can hear me talking on this show, if you get the opportunity to go sit in on a jury, do it. It's probably one of the most interesting and inspiring things as a citizen, because you feel super connected to your community and that you're serving and doing something really positive for your community.
Not only that, I have friends and family that ask me all the time, how do I get off jury duty? And I refuse to tell them. Our government asks we don't have a draft anymore. You pay your tax. But this is like the one thing that we still ask for people. And
Right.
if you were in that situation, you would hope that like-minded people or real people
Right.
would not be looking for excuses to go back to work. And so it's very important to serve on juries and be a part of that process. And so I refuse to help people when they ask me that question.
No, yeah, I always tell people, why would you want to get off? I said, it's the coolest. It's such a cool process. It's so interesting, and you actually see how the system works. And yes, I remember the judge looking down at me, and he was going down the line. Have you ever been arrested? Have you ever been arrested? And he asked me, and I was like, I wonder if this guy's going to do a background check. Well, yeah, I kind of hesitated. I was like, well, yeah. He was like, I have to ask. And I was like, disorderly conduct, college. He's like, next guy.
Been there, done
Yeah.
that.
He was like,
Right. Is that it?
yeah,
We're making him the foreperson.
yeah, great.
He gets it.
So voir dire is your most difficult. What's your most difficult part of the trial? Preparing or being involved in the criminal trial.
Not being a slave to my notes, listening. We go in there and we prepare so much, and oftentimes we want to rely too much on our preparation. If I'm doing a cross-examination, I've got not a script, but I've got my outline. And I have this idea of where I know where it wants to go.
Right.
But oftentimes someone gives you an answer and it throws you off. And you got to be able to listen, think on your feet, and trust your preparation and the evidence where you can go exploit that or examine that. And too many times, I think a lot of lawyers, they get thrown off by that because they're stuck to their script. So I think listening in trial and not being stuck to my notes and my script is one of the pitfalls that I try to avoid.
Very cool.
I would agree. Cross-examination is probably the hardest thing. I've been in trial and I've had notes I prepared, for 2 days for this witness. And I just throw them away.
Cross-examination means that you go second. I'm questioning
the
somebody?
prosecutor asks the witness questions, open-ended questions, and
Okay.
then we ask leading questions, obviously trying to
Okay,
get
so
what we want.
so break that down for me real quick. So the prosecutor, you said, asks open-ended questions.
Right.
Who,
Kinda
what,
like,
when, where, why.
What
Who,
happened?
what, when,
Tell me
where,
what
why.
happened without trying to infer an answer.
Okay.
And then we should ask most of the questions are leading questions, meaning, hey, you did this, correct? You know, kind of forcing the witness to say what it is we at least try to get them to say.
So a lead.
Joe, you're
Right.
wearing a T-shirt. It's blue. It has a V-neck. You're wearing, like, leading them into
Right,
it. You're,
okay.
you're feeding them the answer
Okay.
into yes and a no.
Is that correct? Yes, that's
Yeah.
correct. Yeah, okay. That's-
But I mean, you could only lead so much when the witness says, "No, you're wrong," you know, or they'll stop you. Or if you have a witness who's a female who's crying on the stand, okay, your whole approach of getting aggressive on a witness is going to go out the door because you can't start asking hard questions to a female who's crying on the stand. You can if you want to, but then the jury's going to take it, you know, hold
they're
it
going to
against
think
you.
you're a
and think
dick, and they're
jerk.
going to say,
Exactly.
hey, come on, take it easy on the girl.
Yeah, they may be quiet, but then at the end of the day, you're going to find out what they thought when they found your client guilty.
I remember
So,
getting a not guilty
yeah.
once in state court where it was, I was cross-examining a girl and she started getting so nasty with me. And so I just backed off. I was like sweet as I could be and asking questions. And, you know, later jurors, it was a not guilty, jurors came later and were like, she was so mean to you. We didn't like her. And it's because you have to listen, you have to pay attention, you have to be in the moment. As Peter said, you can't be so focused on notes and preparation that you're not seeing what's right in front of you, opportunities right in front of you.
Absolutely.
It's like sports. You know, you watch film, you prepare for the game, but sometimes things just happen, and
Sure.
sometimes you get punched in the mouth, and it's how you respond and how you go once you get that curveball. And I think
Right.
that's what differentiates the good from the great when it comes to trial lawyers.
Yeah.
Yeah, it's super interesting. One of our producers wants to know if you guys can tell us how discovery impacts the pretrial process in Florida as compared to other states, if you know. Because I know Florida has some unique laws also that they're different from some.
Well, depositions. We
Yeah,
had talked.
that's
I think
the
we're
main
one
difference.
of.
and that's only in state court.
Yes.
Right.
You can't do that in federal.
It's one
no.
of the few states that
Yeah,
still
a lot.
allow
We're one of three.
depositions.
Oh, really?
We're one of 3 states, I believe. And
Okay.
we have a fact checker. We can look that
Yeah.
up.
Can
I
you tell us the other 2 states, fellas?
I believe we're one of only 3 states that even allows depositions on criminal cases. And that's just so important. And that changed the game because you have an opportunity to interview your witness beforehand so you know what's coming. If they change that story, you can impeach them. But then there's also a negative to it. You know, if you do your deposition as if you're going to cross-examine them, now that witness is getting used to your cadence, they're getting used to the way you ask questions, and they're kind of getting a feel for you. So it can work both ways, but it's more positive.
You can
than
get
negative.
witnesses out of there too. you
Yeah.
know.